Today we have Mitt Winter of Kennyhertz Perry joining us. It's almost time for people to go back into the offices and workspaces. So Mitt, thank you so much for joining us today. I know there's lots of questions out there and you have a great presentation for us today. Would you want to go ahead and just get started, please?
Sure. All right, I'm going to go ahead and, is my screen shared right now or do I need to share it again?
You can share that for us, Mitt. That would be wonderful.
All right. All right. Can everyone see the PowerPoint now?
Mm-hmm.
Yes.
All right, perfect. Thanks for the introduction. As Deb said, my name is Mitt Winter. I'm an attorney at the Kennyhertz Perry law firm. We're located right at Shawnee Mission Parkway and State Line, right on the Kansas side. We're a boutique business and litigation law firm. I've been with the firm for a little over a year, and I was with Precautionary prior to that. A large part of my practice focuses on helping businesses avoid and navigate liability issues and then litigating those issues when necessary. As you can see from the PowerPoint, today's webinar is entitled Get Back to Work, but How? Steps businesses can take to minimize coronavirus liability risk. The main focus of the webinar is going to be on steps that businesses can take before and after they reopen to avoid having employees or customers hold the business responsible in the event that an employee or customer does contract the coronavirus or claim or allege that they contacted the coronavirus while at the business. Let's see, I'm having trouble going to this next slide. There we go. All right, coronavirus litigation has already begun. As of a few days ago, when I was putting this presentation together, there had already been more than 800 coronavirus-related lawsuits filed. I'm sure as many of you are familiar with the saying that you should never let a good crisis go to waste. Well, there are obviously some attorneys who are taking that advice to heart with the current situation. The claims that have been filed related to the coronavirus have been on a wide variety of things. Some of the first lawsuits to be filed were by businesses who filed claims for business interruption insurance and had those claims denied. There have been some class actions that have been filed related to that. There have been some lawsuits filed against people who were selling fake cures for the coronavirus. There were also lawsuits for price gouging on things like hand sanitizer and face masks. And more recently, claims have begun to be filed against businesses by employees or customers who are alleging that the business failed to take the proper measures to protect its employees and customers and that they contracted the coronavirus as a result. Some prominent examples of lawsuits along these lines that have been filed already. Walmart has been sued for negligence by an employee who alleged that Walmart failed to provide face masks for its employees and that it let sick workers stay on the job and send those sick workers home. The cruise lines have been sued for their handling of the coronavirus situation. There have been a number of lawsuits filed against cruise lines such as Princess and Carnival for customers who are on cruises who contracted the coronavirus. Those cases allege that the cruise lines didn't take proper precautions in preventing people from getting sick, and then once they knew that people were sick, not isolating them and handling that correctly. And then in terms of smaller businesses, there have been lawsuits filed against things like yoga studios, massage parlors, a ski resort has been sued. And those were all cases where customers alleged that they contracted the coronavirus while they were at those businesses, and that because those businesses did not take the proper precautions to protect them while they were there. As I said, there are attorneys already looking to file lawsuits related to the coronavirus, and there are searches that are actively underway for potential clients to serve as plaintiffs in some of these lawsuits. The searches I've read about so far have been looking for employees of what are considered workers at essential businesses that have been open the entire time that the stay-at-home orders have been in place. And so that includes employees at things like grocery stores, delivery drivers, restaurant workers. I read an article the other day where a plaintiff's attorney was quoted as saying that the response to the searches has been unbelievable so far. So this tells me that employee liability cases for these essential businesses are only going to ramp up from what has already been filed. You know, on one hand, this isn't that surprising to me. I'm sure that there are a lot of employees at those types of businesses that are, you know, aren't super happy. They've had to go to work this whole time and probably are a little scared and maybe feel their employers haven't taken the proper precautions or done a good job of communicating the steps they've been taking to protect their employees. So there are probably some employees of these types of businesses who are more susceptible to serving as plaintiffs in these types of cases. So in addition to these searches for plaintiffs who are employees of essential businesses, I'm sure at some point in the near future, if it already hasn't happened, attorneys will be searching for plaintiffs for other types of businesses that are beginning to reopen besides the essential businesses. You know, things like restaurants that'll be reopening or have already begun to reopen in certain places where you know, the general public will be allowed to go into those places. I'm sure that attorneys will be looking for those types of employees as well who might contract the coronavirus and think they got it while they were on the job. If an employee or a customer does bring a lawsuit against a business for allegedly contracting coronavirus while they're at that business, there are a few types of claims that they are likely to bring against the business. The first would just be a general negligence claim. Under negligence laws, people's actions are judged under a reasonable person standard. So in a general situation, if a person is injured and it's a result of someone not acting in a reasonable manner, then the person who did not act reasonably could be held liable for the injured person's damages. So in the coronavirus context, a business could be held liable by an employee or customer that contracts the coronavirus if the business did not take reasonable measures to protect the employee or the customer from being exposed to the virus. State consumer protection laws or misleading advertising statutes could also be another avenue for claims to be brought by, this would be by customers. These types of laws generally prohibit businesses from engaging in false or misleading advertising. And so in the coronavirus context, a business could get into trouble if it makes false claims about the steps it's taking to protect its customers. Misrepresentation claims would be similar to the consumer protection law claims. These would be based on making of false statements about precautions being taken to protect employees, or sorry, to prevent coronavirus exposure to employees or customers by a business. So the rest of the presentation today is going to cover some steps that businesses can take to minimize their liability risk to their employees and their customers. I'm going to go over 6 topics, 6 areas where employers can take steps to minimize their liability risk. The first category is going to be to follow state and federal orders and guidance. Second category is going to be follow industry-specific plans and guidelines. Third category is going to go over employee screening and testing for the coronavirus. Fourth topic is going to cover waivers and health directives. Then the last 2 topics will just be about not overselling, what it is you're doing to protect customers and employees from the coronavirus. And then the last topic is just going to be having a plan of attack for how you're going to protect your employees and customers. All right, to start off with state and federal guidelines and orders, I'm going to cover Johnson County and Kansas, since this is for the Northeast Johnson County Chamber of Commerce. I know around the Kansas City metro area, there are a number of different orders and plans, since we're right on the state line, but I'm just going to cover Kansas today. And Johnson County luckily made that job a little easier for businesses by just adopting the Kansas plan, instead of having a plan that, you know, conflicts with parts of the Kansas plan or starts on different dates. They just went ahead and adopted the exact Kansas plan. The only difference is that Kansas's phase 1 began on May 4th, so Monday of this week, and Johnson County does not begin phase 1 until May 11th, this coming Monday. So Johnson County is still under its stay-at-home order, while other parts of Kansas have had their stay-at-home orders lifted, unless their local government extended it like Johnson County did. Okay, the Kansas plan has 4 phases, and in each phase, restrictions on what types of businesses can open and how many people those businesses can have will be loosened in each phase. And while each phase has a date attached to it currently, those dates are not set in stone, and each phase will only be moved through as long as certain milestones are met. The milestones that the governor set out for moving from phase to phase are testing rates, COVID hospitalization rates, the ability to contact trace the spread of COVID, and the availability of respirators and masks for hospitals. Just before I go through the different phases of the Kansas plan and what types of businesses can open during those phases, just want to know it's very important for businesses to adhere to the directives on when their type of business can open. I've already heard of some businesses that are planning to open before their type of business is supposed to. That's just a very bad idea. If one of your employees or customers were to contract the coronavirus during a time when your type of business is not supposed to be open, that's just inviting a lawsuit to be filed against you. Okay, the Kansas plan, phase 1. Under phase 1, all businesses that are not specifically excluded from opening can open if they can do 3 things. And again, for Johnson County, this starts on Monday, May 11th. The first requirement is that they're able to maintain at least 6 feet of distance between all of their customers. One thing I forgot to mention at the beginning when I was explaining who I am and who I work for, in addition to being an attorney, I also own 3 exercise studios that are all in Johnson County. So in addition to being an attorney, I'm also a small business owner who's having to deal with many of these issues myself. And so I understand how it can be scary for businesses and how it can be confusing. And so I sympathize with everything that the business owners are going through in this situation. and understand how it can be hard to implement some of these things. So for example, this first requirement of maintaining at least 6 feet of distance between consumers at the exercise studios I own, the manager has already marked off areas in each of the exercise rooms where each client must stay during the entire class that they're at. It's like a little square that they have to stay in, and each square is 6 feet away from another square. This could be harder for different types of businesses to monitor, such as retail businesses where you just have customers walking all over the store, getting in lines. So it'll be important for businesses to make sure that their employees understand what the rules are and that they're doing their best to ensure that customers are staying 6 feet apart. It's not going to be an easy thing to do, so it'll take some people being aware and constantly monitoring where customers are. The second requirement for businesses to open is that they have to follow fundamental cleaning and public health practices. The Kansas plan that was submitted or created by the governor has a list of these practices. And if people haven't already seen that, at the end of this, I can give people a link to that plan so they can take a look at it themselves. But some of the examples that are included are to reconfigure your space to ensure that there is social distancing, establish strict and routine cleaning by sanitizing frequently touched surfaces, to provide signage regarding social distancing and using cloth masks for employees, or requiring them for your customers. Some businesses have chosen to do that, some haven't. That's going to be up to each business to decide whether they want their customers to do that. And as with all of this stuff, the practices that each business engages in is going to depend on the type of business. Certain types of businesses will have more close contact between employees and customers, and so they're going to want to implement certain procedures, where other businesses, they hardly have any interaction with the general public. So those types of businesses are going to have to put in different types of precautions and plans. The third requirement for a business to open is that they have to be able to avoid instances where groups of more than 10 people are in one location and unable to consistently maintain 6 feet of distance between each other. When I read this requirement, it was kind of confusing to me at first how it matched up with requirement number 1, that there has to be 6 feet of distance between consumers. But Kansas has issued some FAQs that have cleared this up a little bit. So this requirement does not place an occupancy limit on businesses. So it does not mean that businesses in phase 1 can only have a maximum of 10 people in the business. It just means that you can only have groups of 10 people together for a very small amount of time. So this is talking about places like lobbies or bathrooms or locker rooms. You have to be able to limit those situations where people are not able to social distance. Groups of 10 or more are not able to social distance for a period of time, more than just a few seconds walking into a location or something like that. An example that the Kansas FAQ gave was at a restaurant. They said, restaurants, you're allowed to go into a restaurant with 9 friends or family and sit at the same table as long as your table is 6 feet away from other tables. But it said restaurants are not allowed to sit 10 strangers together at a table without 6 feet of distance between each person. So depending on what type of business you have, restaurants is a good example. The FAQ is pretty clear on that. But for most businesses, you're not going to have people coming in and sitting at tables like at a restaurant. This last requirement is going to apply to things like people standing in line to buy something at a grocery store, people sitting in a waiting room for something. So you want to limit instances where 10 or more people are within 6 feet of each other. So if you're standing in line, you want to have markers showing where people should stand that are at least 6 feet apart, things like that. And a lot of businesses I've heard from are not letting people come in, like for an exercise class, for instance. They can't come in earlier than 5 minutes before the class. They're not allowed to sit in the waiting room. They have to stand in a specific spot while they're waiting for a class. So those types of things will have to be implemented by businesses. And in phase one, telework is still strongly encouraged, and businesses are advised to minimize or eliminate non-essential travel. In phase one, there are some businesses that are specifically not allowed to open. Those businesses are bars and nightclubs, but those type of businesses can still continue curbside and carry out service. Theaters, movie theaters, and indoor activity places for kids like arcades and trampoline parks are not allowed to open. Fitness centers and gyms are not allowed to open. And then things like nail salons, barbers, tattoo parlors, tanning salons, other personal service businesses where the employee and customer have a lot of close interaction, they're also not allowed to open. So under the Kansas plan, phase 2 is supposed to begin no earlier than May 18th. But again, that's just assuming that all of the 4 indicators are moving in the correct direction, and the governor will issue another order at that time saying we've moved into phase 2. The earliest it could be is May 18th. It could be later. In phase 2, it has the same 6-foot social distancing requirements. It has the same cleaning and hygiene requirements as phase 1. The only difference is that instead of limiting what are called mass gatherings to 10 people, now you can have instances of 30 people who are within 6 feet of each other. And you have to be able to avoid instances where more than 30 people are within 6 feet of each other. You know, again, locker rooms, standing in line, waiting rooms, things like that. In phase 2, bars and nightclubs are allowed to reopen at 50% of total capacity. Telework, for those who are able to do it, still strongly encouraged. Sports facilities, like big gyms and sports-specific facilities like indoor soccer, baseball, basketball, those things are allowed to open in phase 2. But kids' summer camps are still not allowed to open. Schools are still closed, things of that nature. In phase 3, which could be no earlier than June 1st, it has the same social distancing, cleaning requirements. The difference is that mass gatherings are up to no more than 90 people within 6 feet of each other. And in this one, there are no specific businesses that are required, that are not allowed to open or allowed to open with specific requirements for that type of business. All businesses can open as long as they can maintain those 3 requirements. Employers are allowed to reduce telework and to bring employees back into work in office settings as well. The last part of the Kansas plan is called phase out, and this will be no earlier than June 15th. Under phase out, this is when stay-at-home orders are all lifted and mass gathering limits are greatly relaxed. And whenever we do enter into the phase out period, the governor is going to issue additional guidelines to explain what will trigger the decision to eliminate all statewide restrictions on businesses and schools. And as with the entire duration of the Kansas plan, local governments have the authority to impose their own restrictions that are stricter than the Kansas plan. So it's possible as we move along into the different phases that Johnson County could issue some stricter guidelines than those that are currently in the Kansas plan. I don't think it's likely, but it's possible. Okay, in addition to state orders, the Kansas plan, there are some federal standards that all employers should be aware of and that they should adhere to as well. The first are OSHA standards. So one of the OSHA standards that will apply and that businesses need to be aware of is the requirement of employers to provide their workers with what's known as personal protective equipment. Under OSHA, all employers are obligated to provide their workers with personal protective equipment that's needed to keep them safe from known dangers while on the job. And the OSHA has said that this does now include the coronavirus. And so PPE is things like gloves, masks, face shields. And under OSHA, an employer can require that their employees wear PPE and observe other infection control practices, such as washing their hands, adhering to social distancing, things like that. Under OSHA's PPP rules, the type of business that you have is going to determine whether and what type of PPP you can require your employees to wear. They break it up into 4 different categories based on the risk level of contracting the coronavirus. The first level is very high risk, and this is, as an example, they gave healthcare workers who are performing procedures on COVID-19 patients. So this would be doctors who are performing, putting patients on ventilators and things of that nature. High risk is also healthcare workers who are exposed to known or suspected COVID-19 patients. So that could be things like nurses, people who are working in doctors' offices and aren't doctors, people of that nature. Then the third risk level is medium risk, and that is defined as jobs that require frequent or close contact with people who may be infected with COVID, but are not known or suspected patients. So this would include a lot of retail settings, which can include grocery stores, restaurants, gyms, and other high density work environments. It could also include certain office environments based on how many people are in that office and how closely the people in that office work together. If your business is considered medium risk, you may need to have your employees wear masks and gloves. It's basically a judgment call for the business. You need to take into account, how the nature of your business, how many employees you have, what kind of contact those employees have with customers and the public. So each business is going to have to make that determination on their own. And some businesses, in addition to having their employees wear masks and gloves, it's recommended that they have physical barriers such as plastic sneeze guards. Some of the grocery stores I've been in while the stay-at-home orders have been in place have those plastic rectangles in front of the cashiers while people are checking out to prevent people from sneezing on them. I'm sure other people have seen those as well. So depending on the type of business, you might also need to put that type of precaution in place. And then the last risk category is low risk, and that is jobs that have minimal contact with the public and other coworkers. And this would include things like low density office environments. In this type of an environment, masks and gloves are not required. So as I said, each business is going to have to determine where they think they fall on this risk scale, and whether they think they need their employees to wear masks or gloves or put up physical barriers. I would advise businesses to lean towards on the side of caution, just for the reason that you don't want your employees coming back and claiming that they got the coronavirus because of something you failed to do. Another OSHA standard that employers will have to keep in mind is what's known as the general duty clause. Under this, employers are required to furnish workers with a place of employment that is free from recognized hazards that are causing or likely to cause death or serious physical harm. And OSHA has determined that the coronavirus falls under those guidelines. I would say as long as you're following your state and local guidelines under the Kansas plan and the PPP requirements of OSHA, you're most likely going to be okay under the general duty clause. It doesn't specifically require anything, and it's pretty broad. So as long as you're following the guidelines for your state and local industry guidelines, things of that nature, you should probably be fine under this. All right, in addition to the OSHA standards, which must be followed, OSHA has also recently issued some guidance for employers to follow in reopening. And this guidance has 3 components to it. The first component is that employers should develop an infectious disease preparedness and response plan. And this suggests that, this will require that an employer sit down and think about the level of risk of contracting the coronavirus that employees have, how they might be exposed to the virus, and the steps they're going to need to address those risks. For example, you'll need to think about things like whether employees need to wear masks, how you're going to limit groups of employees and customers and other people from congregating. Then you're going to need to put all that information together in a written plan and make sure employees know the plan and are adhering to it. With all these precautions that employers need to put into place, it's also very important that they're training their employees on what the plan is and what needs to be done, just for 2 reasons. Number one, so the employees know what they need to do to protect themselves and also to protect the customers. And then number 2, if customers ask what the plan is, you want your employees to be able to correctly pass on that information to customers. As covered at the beginning, you don't want your employees to be giving your customers false information, which comes back to haunt you in the form of a lawsuit later on. The second part of the OSHA guidance is to implement basic infection prevention measures. Some of this stuff is just common sense, such as promote good hygiene, hand washing, covering your sneezes, things like that. Encouraging workers to stay home if they're sick. Establishing policies and practices to increase physical distance among employees and between employees and customers. And then maintaining regular cleaning practices. As with the response plan that I just went over on the slide before, all of your procedures and protocols for these types of things should be written down and employees should be trained on it. The third part of the OSHA guidance is says that employers should develop policies and procedures to promptly identify and isolate sick employees. For example, the policy should specify when and how employees notify the employer when they're sick or they have symptoms of COVID. Employers should also create policies and procedures for isolating people who do have signs or symptoms of COVID. And as with the other components of the OSHA guidance, this should be written down and employees trained on it as well. In addition to the OSHA guidance, another set of federal guidelines have been issued by the CDC. The CDC guidelines are similar to many of the things covered by the Kansas plan and by the OSHA plan. Some examples of things that are in the CDC guidelines are encouraging sick employees to stay home, identifying where and how workers and customers might be exposed to the coronavirus, separating sick employees and if you have a confirmed COVID case, to inform other employees of their possible exposure. Educating and training employees on reducing the spread of COVID. Identifying a workplace coordinator who is responsible for COVID-19 issues at the workplace. This is actually an important one that's not in the OSHA guidelines or state guidelines. It's important to have one person at your business who is the go-to person for coronavirus issues. So if an employee is sick, or they think someone else is sick, or they have a family member who's tested positive or something like that, there needs to be one person that they know they can go to and pass this information on to, and then who's going to be in charge of putting in whatever plan and procedure you have to deal with that situation. Another CDC guideline that hasn't been in the other things I've already covered is to increase ventilation rates and the percentage of outdoor air that circulates into your HVAC system. I'm not sure how easy that would be for most businesses, but it's something to consider. And then CDC also recommends enhanced cleaning and disinfection after a person with COVID has been in a facility. So in addition to the state and federal guidelines, there are many industries that have put out their own guidelines. And depending on whether your type of business industry has issued guidelines, you should also do your best to follow those guidelines as well. As I said, a number of industry-specific associations have come out with their own guidelines, such as the National Restaurant Association. You should review the guidelines for your type of business, implement as many of those as are possible. Many of the suggestions are similar to things covered in the OSHA guidance, the CDC guidelines, the state guidelines, but it's important just to review those to see if there's something not covered in those other guidelines that's specific to your industry that they're recommending. The Kansas COVID website actually does a really good job of consolidating and gathering industry-specific guidelines, and it's at the website that I have right here on this slide, covid.ks.gov/reopen-page/. I've looked at that a few times, and it has industry guidelines for all types of businesses. So I think no matter what type of business you have, you should go to that page, take a look at the guidelines, and see if there's anything in those guidelines that you might not have thought of while you're going through what your plan is going to be for dealing with coronavirus. All right, on to a new topic, something that is probably on the mind of a lot of employers and that I've read a lot about recently in the news is screening and testing employees for coronavirus. So there are a few ways that people are doing this. Some people are taking the temperatures of all their employees every day when they show up for work. And some people have actually begun testing their employees for the coronavirus. And the EEC has issued guidance on those two things. So employers are allowed to take their employees' body temperatures every day. So as an example, for the exercise studios that I own, the manager has ordered those scan temperatures you can put on people's foreheads, and the plan is every day when the employees show up for work, she's going to take everyone's temperature just to make sure they're not showing signs of COVID. The EEOC has also said you can test employees for the coronavirus. Obviously, that is a little more invasive and would be a little more involved and take a lot more time, likely. So I'm not sure how practical that would be for most employers to do that. There's probably certain types of industries where it's more important than others. For most businesses, that would probably not be something they would want to do, but it is a possibility if they do want to do it. You can also ask your employees if they're experiencing symptoms of the coronavirus. You can require employees to stay home if they have symptoms of the virus. And with all of these things, the temperature, the tests, the symptoms, you are allowed as an employer to maintain and store this information, but you do have to keep it confidential. Only people at the business who need to know the information as part of their job are allowed to see that information. Another important consideration for employers is waivers. And these, instead of protecting you from liability from a claim by an employee, waivers could possibly protect you from a liability claim from a customer. I know of a number of industries that have started integrating waivers into their contracts, or they've amended existing clauses in contracts to specifically include the risk of contracting the coronavirus. With the businesses I own, we're having everyone sign a new waiver that's going to include a coronavirus waiver, stating that business will not be liable if they do contract the coronavirus at the studios. With the waivers have to be clear and unambiguous about what a customer is waiving. So it needs to specifically state that they're waiving their right to sue in the event that they do contract the coronavirus. It's a little unclear whether coronavirus waivers would be enforceable, since obviously the coronavirus is new. But with other waivers, waivers are generally enforceable against negligence, but not against intentional, reckless, or grossly negligent conduct. So assuming that coronavirus waivers are enforced along the same lines as other waivers, if an employer is only deemed negligent in, say it's cleaning procedures or something along those lines, it would most likely protect an employer against the claim from a customer. But if the employer's behavior crosses over the line from just regular negligence to gross negligence or reckless or intentional conduct, the waiver is not going to be protective against a liability claim from a customer who does contract the coronavirus. Something that is similar to waivers that some businesses have been instituting are health declaration forms. In a health declaration form, a customer is representing that he or she has not tested positive for or experienced symptoms of the coronavirus. I've seen a few health declaration forms that also require customers to account for all locations they've visited over a certain period of time, be 2 weeks. I've seen someone say 21 days. For most businesses, a health declaration form is probably not going to make sense, just because you would be requiring customer to sign this form every time they walked into your business. That's not going to make sense for most businesses. It would be too timely, or it would take too much time. It would create lines at your door based on the amount of people that were there. I know some restaurants have required it in certain places, so it could make sense for some restaurants. I saw a private plane company was requiring all of their customers to fill out health declaration forms. So it is an option, but I don't think it's going to be practical for most types of businesses. I've also heard and read about some businesses that are requiring customers to have their temperature taken before they enter the business. But as with the health declaration forms, I don't think it's going to be practical for most businesses. It just would take too long, and probably a lot of customers would balk at having their temperature taken by businesses. All right, so kind of going back to at the beginning of the list of things employers can take to avoid liability. One of those things I had mentioned was don't oversell what you're doing. When you're putting together your plan, you need to make sure that you're doing everything that's actually in your plan and that you're telling your employees that you're going to do. It's important to, number one, protect yourself against liability from employees, and also number two, from customers. You don't want to find yourself in a situation where you told your employees that you're doing X, Y, and Z to protect them in terms of possibly cleaning every night, something like that. And then they communicate that to the customers, and then you don't actually do it. You could have an issue with liability for the employee and the customer in that situation. So it's important to consistently follow through with everything that you do include in your plan. Speaking of having a plan, the most important part in warding off liability is having a plan. It's really important to go through all of the guidelines, the Kansas order, and put together a plan of the things that are necessary for your type of business. And then after you put that plan together, you have to ensure that your employees are trained on the items that are in the plan, because for many of the things, the employees are the ones that are going to have to be performing the items that are in the plans and communicating that information to customers. It's also important to ensure that your customers are adhering to the items in your plan. So if you have social distancing guidelines that you're requiring your customers to follow, it's important that you have someone monitoring that and trying to ensure that those plans are being followed. All right, that is what I have put together for my part of the presentation. I wanted to open it up now to any questions that people have. I'm sure people have some questions on things I went over, or they might have questions about other things that they have on their mind. Just wanted to open that up now for questions, if anybody has any.
So actually, Mitt, we had some questions come through the chat.
Okay.
We had one that came through anonymously that just said that someone took a family member to a pedodontist and for an urgent issue, and surprised to see so many teenage patients and staff present, especially since the examinations and work are done inside mouths. What are the current requirements and expectations for professional offices in terms of density of occupancy? And is there a limit of the number of patients an employee should be seen in a day?
I have not. There probably, I would say for medical offices and things of that nature, there might be industry guidelines that talk about that. I haven't seen anything specifically in the Kansas plan or OSHA or the CDC guidelines that talks about that. But in the Kansas plan, as I covered before, there are no strict occupancy limits. It's all based on whether you're able to maintain social distancing. So while a patient is in that office, the office should be doing something to maintain social distancing amongst the patients, and then taking steps to ensure that the patient is sufficiently safe from any of the employees as well, you know, especially in like a doctor's office type situation. You would probably want all your employees to be wearing masks. I'm not sure about gloves, but definitely masks. And you'd probably want your patients to also be wearing masks while they're in the office as well.
So I have had several questions come in from businesses that are asking if somebody is unwilling to come back to work for whatever reason, could be that they're afraid or they might be getting more money for unemployment. What are the employer's rights?
In terms of unemployment, I actually had to look at some of that myself. The way I understand it, I'm not an unemployment attorney, so I'm not going to claim I'm an expert on the unemployment laws at the moment without having done some more research on it. But the way I understand it is that if you offer an employee their job back, say you were closed for a while and they were furloughed, and then they're offered their job back, they're not allowed to claim unemployment any longer at that point. Unemployment it's for people who've been fired or furloughed, things of that nature. And if you're offered your job back by your old employer, as I understand it, you're not allowed to claim unemployment any longer.
Sorry.
Then I was going to say, the other question was about employees who are scared to come back to work. I know there are some EEOC guidelines that I believe have been issued that discuss that situation. You're under the EEOC, you're supposed to reasonably accommodate your employees, and I'm assuming accommodating people who are fearful or have anxiety about coming back into the workplace may be covered by those guidelines. I would have to specifically look at that situation. But I don't think it's a simple black and white situation where if an employee says, I'm too scared to come back into the workplace, where you can just fire them.
So whose responsibility would it be to contact the state saying the change in unemployment? For instance, like we talked first, if they didn't want to come back after being offered the job back.
Right. Well, I think there could be two situations where the state could be notified of a situation like that. Number one, I think the employee or former employee who's claiming unemployment, they have to, on a regular basis, I'm not sure if it's weekly or monthly, I know they have to fill out some paperwork and send that into the State Department of Labor. And then I also believe that when an employee claims unemployment, the State Department of Labor checks in or sends paperwork to the employer or former employer asking if it's correct that the employee is no longer working there and if they were fired. So in a situation where an employee was either temporarily fired or furloughed and then they're offered their job back, I think the employee would have to state that they were offered their job back and that either they decided not to take it, or if they are taking it, then they could no longer claim unemployment. And then number two, the employer would have the opportunity to also fill out the paperwork it's required to fill out stating that it offered the employee his or her job back and that they declined to accept the job.
Thank you. So I have one other question, please. If a business is classified as a medium risk, as you were talking in some of the regulations, is it up to the business to provide the PPE for the employer, or does the employee?
Yeah, that the employer has to provide the PPE pursuant to the OSHA standards, yes.
I'm a little concerned with, is there going to be enough PPE for all businesses to have that? So is it going to be able to be regulated like that?
Yeah, and when I say face masks for PPE, that can, for medium risk and low risk businesses, if the low risk does decide to, even they don't need to, that can be, something as simple as a cloth mask. For most businesses, I think that would be okay. It's not the situation for a medium risk business where they're going to have to get the medical grade N95 masks in most situations. A cloth mask would probably be sufficient.
You've done a great job in putting all of this out, and I really appreciate all of the sites that you've shared with us so that people can go and maybe do a little more research. Because after listening to you, it sounds like we all need to do some good research on our part and be prepared. I know that what I've learned is we need to all have a plan put together.
Correct. I think that's the most important part, is to put a plan together, make sure it's written down, make sure all of your employees are trained on the plan and understand the plan needs to be followed. And then for the foreseeable future, as long as these guidelines are going to be in place, make sure the plan is followed on a consistent basis.
Mitt, we were planning on sharing this out on our social media. Would you also be able to make the slides available if anybody would like the slides so that they can go back step by step?
Sure. Yeah. Yeah, I can send that to whoever I should send those to. Not a problem.
That would be wonderful. You've been working with Nicole, so that would be my suggestion.
Okay.
Are there any other questions before we let Mitt go?
We had one more question, which is, what can a business do if a customer refuses to distance? What should a business, any suggestions?
I think a business, obviously if they have been asked to follow the business's social distancing protocol and guidelines, I think, they have the right to remove them from the business place. Yeah, I could see that situation arriving. I know there have been some situations where businesses have asked customers to put on a face mask, and there have been some situations where the customer wasn't too happy about that, and I think there are some fights or things like that have already happened when people have been asked to put on masks. So it's a tough situation for an employer, especially in a time like this where most businesses are probably not in a situation where they want to anger a potential customer or someone's in their store. When business has been down and been closed for a while, you want to have as many customers as you can. But businesses do have the right to ask someone to leave if they're not following their guidelines.
I don't see any more questions coming in, so I want to give you a heartfelt thank you from the Northeast Johnson County Chamber for spending your time and your expertise with us today. I think we all have some challenges ahead of us trying to figure out exactly where everything's fitting, and I do think that if we all do our parts, and you've given us some great direction today and to how to participate in that, Mitt. So thank you so much for participating. Thank you all for coming.
Yeah, thank you for having me. I appreciate it. And if anybody has any further questions, my email and phone number is on the first slide, and feel free to reach out.
That's wonderful. Thank you so much.
Thank you.